A student in Ohio just finished her master's degree. She did everything right. Good grades, STEM major, OPT approved, H-1B lottery entered 3 times. She lost the lottery 3 times too. Now she has 11 months left on her STEM OPT extension, and she just found out something nobody explained to her on day 1. H-1B was never actually the only door. It wasn't even the fastest one. If you're on an F-1 visa right now, or you know someone who is, this video walks you through the real timeline from student status to a green card, not the version everyone assumes. We'll cover what changed in 2026, where students lose time without realizing it, and the mistakes that quietly cost people their status. Stay till the end, because the biggest risk in this whole process isn't a rejected petition. It's not knowing this information exists until it's too late to use it. Here's the part almost nobody explains clearly. Most students believe the path is F1, then OPT, then H-1B, then green card. 4 steps, 1 order, no other option. That's the textbook version. It's not the only version, and in 2026, it's often not even the fastest one. F1 status runs during your academic program. As of mid-2026, it's still generally granted for duration of status, with no fixed end date tied to a calendar. But a rule is close to taking effect that would replace that with a fixed period tied to your program length. That change hasn't landed yet, but it's coming. And it's exactly the kind of thing students overlook until a deadline catches them off guard. After graduation comes OPT, 12 months, extendable to another 24 if you have a STEM degree. Most people treat this purely as the H-1B waiting room. Enter the lottery, wait, panic if you don't get picked. That mindset is the first mistake, and here's why it matters more than ever this year. For FY 2027, a wage-weighted lottery system is taking effect. Higher salary offers now get a statistically better shot than they used to. If you're a recent graduate on a starting salary, that works against you. And there's a detail almost nobody explained clearly when the $100,000 H-1B fee headlines hit earlier this year. That fee applies to petitions filed for people outside the U.S. If you're already here on F-1 and your employer files a change of status instead of consular processing, you don't pay it. One sentence that got buried under a scary headline, and it changes the math for a lot of students. But here's the part I actually want you to remember from this whole video. You do not need an H-1B to get a green card. If you have a strong academic or research record, publications, awards, recognized contributions in your field, 2 paths let you skip H-1B entirely. EB-2 with a National Interest Waiver lets you self-petition without an employer or a labor certification. EB-1A, for extraordinary ability, has a higher bar, but for the right candidate, it can move faster than several H-1B lottery cycles combined. Filing an I-140 while on OPT is completely legal and doesn't violate your status. If your priority date is current when your work authorization is about to run out, you can move straight into adjustment of status, no H-1B, ever. There's also a middle option, the O-1 visa, which can bridge you after OPT while you keep building toward a self-petition. Now here's the update that made a lot of pending cases feel shaky overnight. On May 22, 2026, USCIS reframed adjustment of status as discretionary relief, something granted in appropriate cases, not something you're owed just for meeting the technical requirements. Panic headlines followed. Here's what it actually means. It doesn't cancel pending applications, and it doesn't eliminate the pathway. It tells officers to look harder at your full immigration history, gaps in status, unauthorized work, inconsistencies across forms. One detail matters specifically for F-1 students. H-1B and other dual-intent status no longer works as an automatic shield the way it used to. A self-petitioned EB-1A or EB-2 NIW case, built on your own record, doesn't carry that same conflict. So the practical shift is this. A clean, consistent immigration history now matters more than it used to. No gaps, no unauthorized work, no mismatched addresses across your filings. And if you're building toward a self-petition, real documented evidence, not something assembled in a rush. Quick example, and this is only an example. A student named Arjun is on STEM OPT with 14 months left, 2 published papers, a patent application in progress, a strong recommendation letter. He assumes none of it counts unless he's famous first. That assumption is exactly what costs people years. Extraordinary ability doesn't mean famous. It means documented, above typical achievement, judged on evidence. Arjun's case is strong enough to start building today, months before his clock runs out. Wait until month 11 to even ask, and there's no time left to gather what a strong petition needs. One more piece explains why some cases move fast and others sit for years. Priority dates. Your I-140 locks one in, and it has to become current on the monthly visa bulletin before the final step. For a few high-demand countries, that wait can stretch over a decade. For most others, in mid-2026, EB-1 through EB-3 have largely stayed current, meaning the I-140 and the green card filing can often happen together, back to back. Same qualifications, completely different timeline depending on where you were born. A real plan accounts for that from day one. Here's something else worth knowing before we get to the mistakes, because it explains why 2 students in the exact same major can end up on completely different tracks. It's not just about grades or degree level, it's about how the case is documented from the start. A publication with your name buried in the middle of 10 authors reads very differently to an officer than one where your specific contribution is spelled out clearly. A recommendation letter that says, "Great student," carries far less weight than one that explains, in specific terms, what you built or discovered and why it matters in your field. This is the difference between evidence and description. Evidence holds up. Description gets questioned. And under the new discretionary framework we just talked about, that gap matters more than it did a year ago. Now the mistakes, because these matter more than any single rule. Waiting until OPT is almost over to even ask the question. Strong cases take a year or more to build. A rushed petition with 60 days left rarely looks the same as one built early. Assuming H-1B is your only shot and never checking whether EB-1A, EB-2 NIW, or O1 actually fit you. Changing employers too early during the green card process. Once your I-140 is approved and your I-485 has been pending 180 days or more, certain job changes are protected. Change before that, and you can restart years of progress. Traveling casually while a case is pending. F-1 is a single intent visa on paper. Filing a green card petition doesn't violate that automatically, but it complicates renewals and entries if it's not handled carefully, especially under the new discretionary review. And the quiet one that catches the most people, reacting to a headline instead of reading what actually changed. This year alone brought fee shocks, lottery changes, and a major policy shift, and almost every time, the real effect was narrower than the panic online suggested. There's a version of this mistake that's easy to miss because it doesn't feel like a mistake at all. It feels like caution. Some students, after hearing about the discretionary memo, decide to pause everything and wait for things to settle down before filing anything. That instinct is understandable, but it's usually backwards. The memo rewards a clean, well-documented history. And the earlier you start building that history, the stronger it looks by the time you actually need it. Waiting doesn't make your case safer. It just makes it later. So here's the honest version of the timeline. For some students, it really is F-1, OPT, H-1B, green card, in that order. For others, it's F-1, OPT, a self-petitioned I-140, and adjustment of status. H-1B never enters the picture. For others, it's F-1, OPT, O1 as a bridge, then a green card case once the record is strong enough. The order depends on your field, your evidence, and how early you start. If there's one thing to take from this, don't wait for OPT to run low before asking what your real options are. Talk to a licensed immigration attorney early. Keep every document organized as you go, and don't assume the lottery is your only shot, because for a real number of students, it never had to be. Think back to that student in Ohio from the start of this video. 3 lost lotteries felt like the end of her plan. It wasn't. It was just the point where she finally asked a different question. Not, How do I win the lottery next year? But what does my actual record already qualify me for right now? That question is the one most students never think to ask until the clock is almost out. You don't have to be in that position. You can ask it today, with time still on your side. This reflects general information about immigration rules as of 2026. It's not personal legal advice, and every case depends on individual facts. Speak with a licensed immigration attorney about your own situation. If this helped you see your options more clearly, subscribe to the channel so you catch the next breakdown, because these rules are still changing, and you deserve to know exactly where you stand before they do.